Welcome to today's discussion. The topic of today's discussion is on territorial and extraterritorial application of the Indian Penal Code. Section 1 of IPC describes the extent of operation of the code. Sections 2, 3 and 4 of IPC deal with the provisions related to intraterritorial and extraterritorial jurisdiction of IPC. There is also a saving clause given under Section 5 of the Code, which is an exception to Section 2 of the Code. Now, let's see the territorial application of the Code. Before the 31st of October 2019, the Indian Penal Code was not applicable to the state of Jammu and Kashmir, or in other words, the code applies to the whole of India except the state of Jammu and Kashmir. The state of Jammu and Kashmir had its own penal code, known as Ranbir Penal Code. But from the 31st of October 2019, all the central laws applicable to other parts of the country are applicable to Jammu and Kashmir too. Thus, as of now, IPC applies to the state of Jammu and Kashmir. Offences committed within the territorial waters of India will be deemed to have been committed in India and is made punishable in India. The territorial waters of India, that is, 12 nautical miles of sea from the baseline, are part of India. After territorial application of the Code, let us understand the personal application of the Code. The Code applies to all persons who have committed an offence under the Indian Penal Code anywhere in India. Thus all persons, that is, citizens and foreigners, who have committed an offence punishable under the Indian Penal Code within the territory of India is amenable to the jurisdiction of the Indian courts and is liable to be punished. India is defined in Section 18 of IPC. Code provides as follows. India means the territory of India excluding the state of Jammu and Kashmir. Article 1(3) of the Constitution defines the territory of India. It comprises a. The territories of the states, b. the union territories defined in the first schedule, c. such other territories as may be acquired. According to Section 1 of the IPC, all offences committed within the territory of India are made punishable in India. According to Section 2 of the IPC, every person is liable to be punished under the IPC, if he or she commits an offence within the territory of India. Every person includes a citizen and a foreigner. Thus it is to be noted that, if a foreigner commits an offence under the IPC within the territorial waters of India, he is liable to be punished under IPC even though the offence was committed on board a foreign ship. Let's see the exceptions to this general rule. The Indian Penal Code is applicable to all persons, both citizens and foreigners, if an offence is committed within India. The exceptions to this general rule are 1. President and Governor, exempted from the jurisdiction of courts in India under Article 361 of the Constitution. No criminal proceedings can be initiated or continued and no process for arrest or imprisonment shall be issued against these high dignitaries. 2. Foreign sovereign. They are completely immune from the jurisdiction of Indian courts, both civil and criminal, by virtue of public international law. 3. Ambassadors and other diplomatic agents. No criminal proceeding can be initiated against them in India for the offences committed by them while they are in the Indian territory. 4. Foreign army. Armies of a foreign state are exempted from the jurisdiction of Indian courts when they are within the territory of India with her consent. Now let's understand the extra-territorial application of the Indian Penal Code. The jurisdiction to try an offence committed outside India is known as extra-territorial jurisdiction of the Indian courts. If an Indian citizen commits an offence under the IPC beyond India, Sections 3 and 4 of IPC are applicable. Sections 3 and 4 of IPC provide for the punishment of offences committed outside India. Sections 3 provides that any person liable, by any Indian law, to be tried for an offence committed beyond India shall be dealt with according to the provisions of this code for any act committed beyond India in the same manner as if such act had been committed within India. Section 4 provides that the provisions of the code apply also to any offence committed by any citizen of India in any place without and beyond India, any person on any ship or aircraft registered in India wherever it may be. Let's also see an explanation given in the code. In this section the word offence includes every act committed outside India which, if committed in India, would be punishable under this code. That is, if an Indian citizen commits an offence under the IPC beyond India, he can be tried and convicted for such offence in India. If any person commits an offense under the code on any ship or aircraft registered in India wherever it may be, he can also be tried and convicted in India as per sections 3 and 4. Let's see the scenario when a foreigner commits an offense under the code on any ship or aircraft registered in India. If a foreigner commits an offense under the code on any ship or aircraft registered in India, he may be tried and convicted in any place in India at which he may be found. By virtue of Section 188 of the Code of Criminal Procedure 1973, previous sanction of the central government is to be obtained. That's all for this video. Click on the bell icon to get notified when we upload new videos. Subscribe for more videos. Visit our website for MCQ examinations and notes on this topic. Happy learning! A video from Law Aspirants Hub.